Kristen McMahon, and I have the pleasure of serving as the president of the Robert H. Jackson Center. I'm going to, at the outset, a couple of housekeeping items. Please make sure your phones are on silent. I know that you think that they are. I promise you they are not, so please check. For the lawyers in the crowd, you should have received an email yesterday from Mary Keating at Phillips Lytle with the packet for today's program. If you did not receive it, that means we do not have an email for you, so we will need one of those in order to send it to you. And then the information that you should have received when you checked in as well, your evaluation form and your attendance form, also remember to turn those in at the end of the day. For those in the crowd who are not lawyers, if you are interested in that packet of information, and it's a good one, it has a brief written by one of Phillips Lytle's summer law students. It also has some copies of the historical document, as well as a virtual copy of the Justice Deferred booklet that is outside. Also, just give us an email and we will happily send it to you. All right, to thank our sponsors. Today's program is sponsored by Phillips Lytle, the Randall J. Sweeney Education Fund at the Chautauqua Region Community Foundation, Chautauqua Abstract Company, the Robert H. Jackson Center Inns of Court, the Jamestown Bar Association, and the American Board of Trial Advocates. And we'd also like to thank the Chautauqua County Historical Society for the loan of some of the Albion Tourget documents that were outside our theater doors. So today, we are hosting you as part of our Constitution Day celebrations. Constitution Day itself is September 17th. And does anyone know why that is? Students, I'm looking at you. All right, so on September 17th, 1787, 39 delegates to the Constitutional Convention met for the last time to sign their names to the Constitution. In the 50s, it started being celebrated as I Am an American Day, and then it was changed to Constitution Day, and in 2004, it became, well, I'll get to that in a little bit. Article 3, Section 1 of the Constitution says that the judicial power of the United States shall be vested in one Supreme Court and other inferior courts as Congress deems necessary. And Article 3, Section 2 says the judicial power of the courts extends to all cases arising under this Constitution. And that's really part of how we get to here today. So as I was preparing for today's program, one of the things I learned was just how deep New York State's history is tied to the issue of slavery. As you came in this morning, you saw the panels from the Lemon slave case, which came to the New York courts initially in 1852. 40 years later, we have the Supreme Court case that is the focus of today's program, Plessy v. Ferguson. One of Homer Plessy's attorneys was Albion Tourget, who lived in Mayville, New York, and is buried in Mayville, New York. And about 10 years after the Plessy v. Ferguson case, W.E.B. Du Bois called on a group of men to gather for two purposes. The first was for aggressive action on the part of men who believed in Negro freedom and growth. And the second was to oppose the present methods of strangling honest criticism, something that I think we're becoming more and more familiar with today as well. This group hoped to meet in Buffalo, New York, but no place there would accommodate them. So they moved across the river into Canada, and they adopted a constitution and bylaws, formed committees, and wrote a declaration of principles. And this is the start of the Niagara movement, which was the forerunner of the NAACP, whose lawyers took a case to the Supreme Court in the early 1950s that overturned Plessy v. Ferguson. And this history is also very closely tied with Justice Robert H. Jackson's history. He was born 4 years after the Plessy decision, and one of his final cases on the court was the opinion that overturned the Plessy ruling Brown v. Board of Education. Now, I shortened something in my introduction. So the full name of the day we are celebrating is Constitution and Citizenship Day. Jackson gave a speech a few months after he took his seat on the U.S. Supreme Court entitled Statecraft Under a Written Constitution. And let's break that down just very quickly. What is meant by statecraft? Statecraft is the ability to be an effective political leader, and it covers all actions that contribute to governing a state or a nation and conducting the work that is required. Jackson said, "No citizenship in the world today imposes upon its members a burden of watchfulness and understanding greater than does the citizenship of the United States." Now, Justice Robert H. Jackson had a great amount of respect for the Constitution, and he considered it a living, breathing document. And he also believed that there was immense importance that the public have a deep understanding of how government operates. Because if future generations do not master that, they will make important decisions without a solid foundation. And so for you students, he had a wish for you. Statecraft is America's youth for the taking. There is no reason why they should delay a single day in contributing their part to public opinion. So I will say to the students in the crowd, when you see something you want to change, figure out how to change it. Talk to people, do the research, look at it, challenge it. This is all part of what it is for you to do as well. So I am pleased to introduce our featured guests for today. Keith M. Plessy is a New Orleans native and is the great-grandson of Gustav Plessy, Homer Plessy's first cousin. Homer Plessy is the named petitioner in Plessy v. Ferguson. He is the co-founder and president of the Plessy and Ferguson Foundation. Phoebe Ferguson is also a native of New Orleans and the great-great-granddaughter of Judge John Howard Ferguson, the named respondent in the case. And in 2009, they co-founded the Plessy and Ferguson Foundation, where Ms. Ferguson serves as the foundation's executive director. Mr. Plessy attended an historic Black elementary school in the 7th Ward of New Orleans, and it was where he discovered his connection with Homer Plessy and his love of drawing. He went to high school at John McDonough and New Orleans Center for Creative Arts, where he graduated in 1976. And in 1979, his alma mater requested that he return to his former elementary school to make the hallways a daily reminder that education leads to great futures. And for that project, Mr. Plessy painted more than 100 images of famous African Americans, including many civil rights icons. That effort sparked a lifelong interest in civil rights history and the role of his ancestors' fight for equality. He takes great pride in sharing the remarkable history of Homer Plessy and the Citizens Committee and their efforts to end segregation laws in the South. He is also a great ambassador of New Orleans history and culture and has been a 40-plus year employee of the New Orleans Marriott Hotel. Prior to her nonprofit work, Ms. Ferguson worked as a professional photographer in New York City for 18 years. In 2001, she went to NYU to study sociology and documentary film. And in 2003, she returned to New Orleans to make A Member of the Club, a feature documentary about New Orleans' oldest Black debutante society and the rise of the Black middle class from 1895 to 2005. Ms. Ferguson moved her business from New York to New Orleans in 2006, and now operating as Bayou and Me Media Productions, she produces videos on the history and culture of New Orleans and social justice areas. Her particular area of focus in both her media work and her work at the foundation is education equity. Ms. Ferguson, along with the other members of the foundation, have been actively involved in community and legislative efforts to stop the privatization of public education in New Orleans after Hurricane Katrina. And in 2006, Ms. Ferguson began documenting the process of implementing the country's first all-charter school system from the perspective of the families, teachers, and students, which resulted in a perfect storm, the takeover of New Orleans public schools, which is an ongoing video series. And today's panel will be moderated by Greg Peterson, one of the Jackson Center's co-founders and of counsel with the law firm of Phillips Lytle. We're gonna have Greg and Keith and Phoebe start.
How did this happen? How did we gather together today on Constitution Day with the descendants of one of the foremost Supreme Court cases in the history of the United States? Because if there was no Plessy versus Ferguson, there would be no Brown versus Board of Education. And how did this happen? I was reading the New York Times, and it talked about the Louisiana legislature authorizing the governor of Louisiana to execute a posthumous pardon of Homer Plessy. In the law business, Plessy versus Ferguson is a known commodity. And there in the article was references to quotes from somebody named Keith Plessy and somebody named Phoebe Ferguson. I go, I bet they might have a number. So the beauty of Google is all of a sudden, boom, Phoebe's number appears. She made the mistake of answering. And here we are a few months later gathering together. So what you were seeing behind us here was the actual ceremony in January 5th, 2022 in Louisiana, whereby the governor was signing the posthumous pardon of Homer Plessy's conviction, a conviction where he pled guilty to violating the Separate Car Act. And this, in fact, was the pardoning of that aspect. And what you have here is the district attorney, I believe, setting the scene, a very 5-minute articulation of it all, which was a perfect setup. And what was fascinating to me was this ceremony brought to light not only Plessy versus Ferguson, but also Plessy and Ferguson. So just curious, Phoebe, you first, how did you even know that was running its way through the legislature, that maybe something you guys, the two of you, started in 2007 may find this kind of attention? Might have to get a little closer.
You're talking about the
pardon, yeah.
Well, actually, we helped instigate it.
Mm-hmm.
So we were approached by a civil rights lawyer in New Orleans who was reading, again, this book that brought us together called We as Freemen, Plessy versus Ferguson. And that book was written by a local historian. And, you want me to go on?
Yeah, sure.
Okay. And what was great, his name is Keith Weldon Medley, and he told the story from the New Orleans point of view. Anyway, she was reading that in 1897, after the decision, Homer Plessy, the prosecutors, wasn't enough that the decision was, that they lost in the Supreme Court, that they were going to go ahead and prosecute him. And that 1897, it was January 11th, 1897, so she realized that was in January of 22 would be 125 years since he had pleaded guilty. And she wondered if we've celebrated every anniversary that's ever come up, if we'd actually celebrated that one. And I said, well, no. But she, because she worked so closely in the civil rights community, she put together in her mind that this might be an opportunity for us to approach the DA's office, because at this time, the gentleman speaking in the video, the DA, Jason Williams, is a very progressive attorney, a progressive DA attorney, and they initiated in the, when when he got into office, he got the former executive director of the Innocence Project to head a civil rights division inside of the prosecutor's office with the mission of maybe not undoing past harms, but reducing past harms to the African American community that they have experienced through these decades and decades and decades of discrimination laws. And so that was the setup, and we were totally on board with approaching them, and we did so, and then they were thrilled because this case would be the most symbolic case they could use to educate the public about, you know, redress, that there is no deadline. It's always time for justice. Like even though it was 125 years ago, this still needed to happen, and this would be a profound way of reckoning with our past.
Well, maybe that's a good segue. This is Orleans District Attorney Jason Williams.
Over a century ago, one of my Orleans District Attorney predecessors prosecuted Homer Plessy's brave defiance of the Louisiana Separate Car Act of 1890. Just one of many Jim Crow laws passed by the Louisiana legislature to codify white supremacy and racial segregation after the Civil War. Homer Plessy died convicted of this crime, but the legacy of Jim Crow laws lived on for generations. Lived on, that is, until a steady stream of civil disobedience by heroes standing on the shoulders of leaders like Homer Plessy risked their lives, causing so much good trouble that elected officials were forced to act. But the legacy of separate but equal still casts a shadow on all of our lives today. That shadow is clearly visible in the gross inequalities we see across this city and across this state, and I say across this country. It was important that the office that prosecuted Homer Plessy be the office to ask for his name to be pardoned. Because we all know that while Homer Plessy's actions at that time made him guilty of a crime under the law, it was really the law that was the crime. My predecessor should not have prosecuted Homer Plessy. Just because a law can be enforced or a person can be prosecuted does not mean that they should be. Slavery was lawful for 250 years in this country. The late Archbishop Desmond Tutu said, "True reconciliation exposes the awfulness, the abuse, the hurt, the truth. It is a risky undertaking, but in the end it is worthwhile. Because in the end, only an honest confrontation with reality can bring real healing. And although our great country has slow-walked its reckoning, the office of the DA will not. America has never had a process of truth and reconciliation, an honest confrontation with the reality of its oppressive past. And we see the direct consequences of this failure to have an honest conversation so boldly in the criminal legal system, most notably with the grossly disproportionate criminalization and incarceration of African Americans. The Orleans Parish District Attorney's Office is now working openly and transparently towards confronting those dire consequences. But while we seek to correct the sins of the past, we must acknowledge my predecessor's roles in committing these sins. if for no other reason than to build the public's trust in our legal system. We must reckon with our past. We must confront, we must acknowledge, and we must humbly ask for forgiveness for the role our legal institutions have played in the apartheid that the people of this country have endured. Let me be clear. Homer Plessy was no criminal. He was then and he is now a hero. And we will do our part to ensure that history reflects just that. Homer Plessy, Louis Martinet, Albion Toujé, and the Citizens Committee belong to a long line of heroic civil disobedience that Dr. King traced all the way back to the early Christians defying unjust Roman laws. The state of Louisiana prosecuted Homer Plessy to make a point of upholding a racist law. And just as these trains are weighing in and hissing the same way they did when he boarded that train, today we make a very, very different point. We now ask our governor, Governor John Bell Edwards, to pardon Homer Plessy from the stain of immorality on our state's history. So let me welcome our friend of New Orleans, friend of justice, our governor, John Bell Edwards.
With the stroke of his pen, Governor John Bell Edwards opens a new chapter in the legacy of Homer Adolph Plessy. This historic posthumous pardon is proof that 125 years after his conviction, the state of Louisiana recognizes and honors Plessy for his role in opening the gates of the civil rights movement of the 20th century. So quoted a guy named Keith Plessy. Keith, so you're listening to this and you're a Plessy. What's your reaction to all this?
Well, on that particular day, when the DA spoke, I described to the audience that day that my feet felt like my feet were not touching the ground, because I thought that my ancestors were actually there with me, carrying me that day. From all the research that we've done in our time, and to have the dream that we've already dreamt a long time ago, to have everybody come on board with our thought of coming together, as opposed to being Plessy versus Ferguson, we became Plessy and Ferguson. And we decided to be friends. You know, it sounds like, people describe us as unlikely friends, but we are intentional friends. We intended to be friends from the very beginning when we shook hands, when we met at Keith Medley's book signing. And, the tie-in with the DA's speech and what followed after with the DA's office was when we brought everything to the DA's office. They went to work right away to find ways to get Homer Plessy this pardon. And in their research, they discovered the Avery Alexander Act, which was written in 2006. And this was written for civil rights activists who were arrested in the 60s, in the 1960s. And it was named after Avery Alexander. And to give you an example of who Avery Alexander was, he once sat in the City Hall cafeteria in New Orleans to protest blacks not being able to sit there and eat. And they were employees at City Hall. And he was dragged up the steps by the police department with his head hitting the steps as they dragged him up the steps by his feet. And he went through that and he survived that. And he sat in with many voter rights demonstrations, housing, and just generally civil rights in New Orleans. And to have his name on the act that actually gave Homer Plessy the pardon was an extreme honor to both of us.
You say what the act was.
Oh, it's the Avery Alexander Pardon Act. And it was written for those who, in the 1960s, were in the sit-ins, the freedom rides, and we have several freedom rides and sit-in survivors in New Orleans that went through those 1960s. And he wrote the Pardon Act so that they could get pardons, but they all refused. So from 2006 to 2022, nobody decided to sign up for that pardon. And it was just sitting on the books waiting for Homer Plessy, who 125 years ago committed his so-called crime of violating the separate car law.
Wow.
So he would be the first in
Wow.
Louisiana to receive the pardon under the Avery Alexander Pardon Act.
Another quote that day, "We cannot undo the wrongs of the past, but when our government officials publicly acknowledge them and take steps to legally correct them, we give hope to this generation and the next who will continue to be on the front lines in the fight for justice and equity in America." So saith Phoebe Ferguson. What's your sense of all of this? Do you have a pardon? Your great-great-great-grandfather was the judge who actually was involved in the case and the conviction, so you were part of that. And what is you as a descendant, how do you feel about this?
I was thrilled.
Yeah.
What was I going to say? When you look at the trajectory of the case, so most people that know about the case, they know about the Supreme Court part of the case. They know that it was a civil rights challenge to oppose the discriminatory law, which said the Separate Car Act, which was written in 1890 by the Louisiana legislature, segregated blacks and whites in separate train cars traveling within the state of Louisiana. And these laws we weren't the first to pass these laws. They were happening all over the South. But when the state passed this law, there was in New Orleans a very different culture and climate than many other southern cities, and that was that we had this Creole community of highly educated men that many had been from French-speaking families and educated in Paris, but not all of them.
And women.
And women, yeah. Am I getting off track? The judge. In this case, many of those, or some of those men, 18 men that ended up comprising of the Citizens Committee, had also been a part of writing the 1868 Constitution in Louisiana. You know that in 1868, all the southern states that had seceded had to write a new constitution, which included this civil rights being granted to newly freed slaves. And so they were a part of that. So then, 30 years later, or 25 years later, and having gone through Reconstruction with integrated schools and basically granted all rights except, male suffrage came later, in 1870, and then this period of time post-Reconstruction in which all of these civil rights were removed. They were outraged by this law, and they came together to organize and to fight this separate car law, and their mission was to get it to the Supreme Court. But they had to start in New Orleans with the local district court. And Judge Ferguson was tapped to be in that court just a few months before this case happened. And so he was the first roadblock they had to get past. And so that story, we probably get into it a little bit more later. It's, this is where, when you dig a little deeper, you find out details that are quite surprising.
Well, your great-great-grandfather was from Massachusetts
Yes.
and a carpetbagger, similar
Yes.
to a guy named Albion Tourget, who we'll also talk about a little bit later. And he came down there and stayed there and became a judge. And in 1891, the legislature passed a separate car law, and I think we just briefly talk about that, which mandated, the law mandated, and this is sort of unique, mandated that equal but separate accommodations for the white and colored passenger trains in the state. So they mandated it, which didn't make anybody really happy with regard, certainly the trains.
Right.
I mean, the people who actually ran the trains were mandated to have separate cars. So this committee that you talked about, headed by Louis Martinet. And do you want to briefly talk about Louis Martinet? I don't know if either of you have a little bit of a quick bio on him, because he clearly is a major player.
Well, in terms of his relationship with Albion Tourget
Yeah.
and with Homer Plessy personally, because I've talked to some of Martinet's relatives in California. And they mentioned the fact that I'm pretty sure that Albion Tourget had a lot of influence in selecting Homer Plessy as the plaintiff, but also did Louis Martinet, because from the family member I heard that he was the one that talked Homer Plessy into volunteering as the plaintiff for the case. So they both had, I think, a serious influence on Homer Plessy volunteering as the plaintiff in the case.
Well,
Since you're Keith Plessy, talk about Homer Plessy. Who was he?
Born in, and this is something that on a lot of documentaries and so forth, and even the governor stated it wrong that day. He was born March the 17th, 1863. I have his birth certificate. So everybody says 1862. I don't even think it was a thought in his daddy's mind.
yeah.
But anyway, they always say 1862, and it's on the tombstone. So it's really wrong, But 1863, according to his birth certificate. Born in New Orleans, and grew up in pretty much, I'd say, 1863, Abraham Lincoln signed the Emancipation Proclamation, and he was born not too long after that. I think that was January of 1863, the Emancipation Proclamation was announced, and he was born in March that year. His upbringing in New Orleans was pretty much the Reconstruction era, and in its full force when you had Union troops in New Orleans enforcing the law. So he was able to attend the same schools as white children. He was able to marry a white woman if he chose. He was a free person of color from his lineage and in his, I would say, his DNA. In 1790, his great-grandfather, his maternal great-grandfather was white. He married a free woman of color. They had children, and I would say in the 1860s, his maternal grandfather was fighting for civil rights. And in the 1870s, his stepfather, because his father died when he was very young, his stepfather was fighting for civil rights. So he was exposed to it in stages of his life growing up in New Orleans. So it was in his DNA to fight for his freedom when his rights were being taken away. So he was one of the, also he was with a group of activists who advocated for the public schools to stay open at the late stages of Reconstruction, where post-Reconstruction was about to happen and rights were being taken away. He was part of the Justice, Protective and Educational Social Club, and that sounds like a little club that got together and had parties, but they fought to have public schools open for black children when they were closing them. And he was part of that group before he became part of the Citizens Committee. Wasn't a full force member, but he was selected, as I was saying earlier, because of his activism in the community. He was selected as the plaintiff in the second case.
Well, also, I think he was selected because of his look.
Yes.
He was a,
Well, they say 7/8 white, 1/8 black. That was according to his great-grandmother, and it's a long story, so I'll just state that she had her freedom granted to her by the governor of Louisiana in 1779. So that's how they became free people of color, from her purchasing her freedom under Spanish colonial rule in 1779. And the governor of the state of Louisiana, which was the Louisiana Territory, which stretched all the way up to Canada at the time. It wasn't part of the Union. But just recently, they've been included in the American Revolution, sons and daughters of the American Revolution, because they helped Washington win the war in the American Revolution. And Homer Plessy's great-grandmother and great-grandfather were part on his mother's side of his family. They were part of the American Revolution.
interestingly enough, and Stephen Luxembourg in his book did a little research and did the census. In 1880, Homer Plessy, in describing what he was at the time, they could put an M for mulatto.
Yeah.
In 1900, it was B, black. 1910, B, black. 1920, he puts W, white.
Yes.
Because he's I guess the term's an octoroon, is there 1/8 black? And yet that becomes a pivotal part of the arguments that go into the Supreme Court is the definition of race, of which Louisiana did not have, though they were trying to enforce race.
Well, I can tell you, in my family, there were several Plessys who changed their names because they appeared to be white, and they were able to vote because the voting rights were taken away. That's how you were able to be on the census as a voter.
And that's why he
And, and it was strange in his case because he never changed the last name, and he was involved in the case. So it would seem as though he would be a target, and he wouldn't be able to vote, but he was able to cross over. And I was talking to someone this morning, and they said that Albion Toji was a member of the Scottish Rites Masons. So was Homer Plessy.
Well, let me just tie this all together in a perfect world, because this particular facility that we are in, the Robert H. Jackson Center, in its prior iteration, was owned by the Scottish Rite Consistory, which is part of the Masons. So the Masonic Celebration Center were right here, where Homer Plessy was a member and Robert Jackson was a member. It's a beautiful thing.
Do they know what the Masons?
Who knew? Maybe they're all brothers.
Do you all know what the Scottish Rites Masons?
The Masonic Masons, by the way, there's actually up top there is a symbol, which is a Masonic symbol for justice. That's up there. I won't go into great detail about the Masons. You can look it up, but not now. Do not look it up now, but on the Masons. But that's an interesting toy. And Phoebe just mentioned the fact that probably in 1920 he changed, and legitimately so, his designation to white because of voting. Probably that was it. So we'll go back to the case. We have the Separate Car Act, and doing a little research on Chautauqua County, Mayville, New York, has an attorney by the name of Albion Toji. Briefly, he was a civil rights activist. He was a writer. He wrote various books which got a lot of attention, including this one called Buttons In, right here. And as a result, he was writing for a Chicago paper and wrote a letter to the Louis Martinet in 1891. it was a newspaper article writing specifically against the separate car law. He'd read it and wrote about it, which then got Martinet's attention in the committee, and then they contacted each other. And it was at that time where Albion Tourget in Mayville, New York, right up the road, Chautauqua County, was asked to participate in a potential legal case. And there's correspondence, which we will see later today, on that subject. And so he's brought in, they actually raised money for his legal fees. He turns it down. He takes no remuneration. He said he will take this case on for principle. So hence was the beginning of the introduction of Albion Tourget, a white Republican carpetbagger who was in North Carolina for many years, was a judge in North Carolina, hence became Judge Albion Tourget, and is very sympathetic of the plight of the colored, at the time was the term, in Louisiana. So do you want to kind of, you have a sense of what happens after that to the committee, you know, how they decide and to proceed? If you want to do that?
Well,
Or Keith, go ahead.
The two cases.
oh,
1 and 2.
okay, short on the, okay. You want me to? Okay. What Keith's pointing out is that the other thing that's not as well known about the origin of the case in New Orleans was that the 18 members of the Citizens Committee, which Louis Martinet was one of the founders. Oh my God, I lost where we're going.
Well,
Oh, Daniel
let
Day-Dun.
me help you with that.
Yeah, okay.
Okay, so I'll do it briefly.
Okay.
All right, so there were 2 cases involved in this Plessy v. Ferguson finale. Plessy v. Ferguson being the last, but the first was Daniel Day-Dun was a musician, and he was a member of the Creole Onward Brass Band and the son of Rodolphe Day-Dun, one of the Citizens Committee's founders. His case was an interstate case, and what they were attempting to see if they could change this law in Louisiana, the separate car law, by trying a case on the interstate level, which it was thrown out. And they thought for a minute that when they would challenge the intrastate law, which was written in the state of Louisiana, separate car law, that they would have to select someone similar to Daniel Day-Dun, who could appear to be white. And Homer Plessy was selected as a result, being that second case, and became the plaintiff in Plessy versus Ferguson eventually.
Yeah, and just add a little flavor to that. The first case, they bought a ticket to go to Alabama. Hence, it was an interstate travel, and there had been decisions that, in fact, the applicability did not apply in this particular state law. So, in fact, they won.
They
They won, but they didn't want to win.
It was a federal.
Exactly, it was a fact because
It was a federal law, which is that they couldn't regulate it on, on states level.
It didn't directly challenge
Correct.
Louisiana.
Right.
So you win, but you lose, and so hence.
And as a matter of fact, that was overturned actually in Judge Ferguson's court. He
really?
threw it out because simultaneously, the federal law was that you couldn't regulate the interstate trains to say that you had to be separate.
So now they reach out to somebody else. This is your great uncle or great uncle Homer Plessy, and who looks the part. And it's literally a staged arrest. I mean, it's everybody's on board.
Well, in addition, the railroad company, East Louisiana Railroad, was totally against the segregation law. And just like you were saying earlier, that it was difficult for the conductors to determine who was white, who was black, how to seat them in the separate cars and so forth. You had a business monkey wrench in there somewhere where, if somebody was going to a business appointment and somebody black showed up, and there was not a separate car attached to the train. They had to wait until that train was attached so that one man could sit in one car in the back while the other passengers waited, and whatever appointments they had, they were late for.
Oh, my golly.
And
So-
it cost them $1,500 to add one car, which was a lot of money in those
So,
days.
you know, being those elements involved, it was difficult for the railroad company to make money. So they were in the business of making money, and they wanted to sell all first-class tickets. They didn't want to sell a second-class ticket or a separate car. So they were in on the plan with the Citizens Committee, Albion Torje, and what I'm finding out more now is that Albion Torje was there from the very beginning. And I was thinking he came along later when he went to U.S. Supreme Court. But I'm learning more now today that, you know, I just found out last night doing a lot of reading that he was involved from the very beginning and all the way through, all the way to U.S. Supreme Court.
Well, we clearly won a test case, and then, in fact, the second one, June 7th, 1892. So now we're on the 130th anniversary, sports fans, of that. If you want to be an anniversary person, here we are. And what happens next? I mean, he literally sits down. Here's a 7/8 white person, sits in a white car, and he has to be identified as not being white.
Well, the perfect thing that happened was that they had it orchestrated whereby he could be removed from that train without incident. Because in those days, right in 1891, as you mentioned earlier, when it started, there was 11 Italians that were hung in Congo Square and shot hanging from the ropes. Their case was a case that was involved with the chief of police being murdered, and there was a war in the docks between Italians and Irish. And the Irishman was the police chief, and he was murdered by, I say, a group of Irishmen. Everybody knew that. But they charged the Italians with the murder. And when they were acquitted, coming out of the jail, the mayor of New Orleans incited a riot. And I won't call it a riot, it was a massacre. They took these guys as they were being shipped from the court, being acquitted, kidnapped them from that area, brought them out to Congo Square, hung them, and shot them from the ropes as they were hanging. Maybe one escaped out of the whole group. But that's the climate that was in Homer Plessy in 1892, a year later, decides to get on this train with the help of the Citizens Committee. So they had to orchestrate that incident to where he would be protected. You know, the bail was set. They had people helping them. The arresting officer was working with the Citizens Committee. So when they took Homer Plessy from that train on that day when he purchased the ticket, they whisked him off to central lockup and put him in jail, but they quickly got him out the very next day, and without incident. So it was orchestrated from many players, you know, the railroad company, the Citizens Committee, the lawyers, everybody was involved, and the plan worked. And the eventual thing they wanted to do was to go to U.S. Supreme Court to try this, because there were laws across the South, separate car laws that had been existing for 10 years before ours in Louisiana. So we were like 10 years after Tennessee. So these laws, they wanted to wipe them all out across the nation. So they got their day in court, but like we were saying, it was a loss. And after he lost the case, he goes and signs as guilty and pays a fine in Louisiana in the very next year. But I was thinking, he said something about football. You know, we were talking earlier about why would they not mention Plessy v. Ferguson in the obituary of Albion Torje, in Judge Ferguson's obituary. In many instances, there was opportunity to mention the case, but it was ignored. But I was thinking football, and I mean, this year you guys are going to the Super Bowl, I think.
Yeah. How about those Bills?
But if you look back at their history, they went to the Super Bowl 4 years in a row, and nobody ever mentioned these guys for what they did. They lost 4 years in a row. But to get there 4 years in a row and not have that story told, it's almost like I feel about Homer Plessy's story. You know, I mean, it's a loss, but you look at the victory of them making it there 4 years in a row, And nobody ever talks about that. They always mention the winners. But back to history.
Well, I love Keith Plessy and Phoebe Ferguson because here they play to the crowd. So how they could tie in, and even I could not figure out how Keith Plessy could tie in the Buffalo Bills and Homer Plessy and play to this crowd. That's beautiful.
Yeah, it's
it's beautiful.
good.
Nicely done.
Yeah.
So the case itself works its way now. He's arrested. He's arrested, and then kind of take it from there, Phoebe. And your dad gets, or your great grandfather gets involved.
Okay. This is interesting. Can I give a little?
Sure.
So Judge Ferguson was from Martha's Vineyard, was where he grew up, right? And his family were whalers. And he decides he wants to get to be a lawyer, so he goes to Boston. And in those days, you could study under another lawyer in order to pass the bar. You didn't necessarily have to go to university. And so that's what he did. He studied under a lawyer named Hallett there, who at times was an abolitionist and attorney general. And anyway, he was born in 1838, and so was Albion Tourget. Albion Tourget was born in Ohio, and as I understand it, in kind of a anti-racist hotbed, his community, and so that his beliefs in equal rights was embedded in him as a very small child. Judge Ferguson, on the other hand, not so much. So he's in the late 1850s and early 1860s, he's studying law and practicing law in Boston, and Albion Tourget, in the meantime, has joined the Union Army, gotten seriously wounded, went home, recovered, re-enlisted, back in the Union Army, gets further injured, comes back. While he's recovering, he gets married. He finishes his studies because he left, and re-enlists again. He just couldn't seem to, and he got even more seriously injured. Judge Ferguson doesn't join the Union Army at all. I don't know whether, he must have paid someone, to take his place? Wasn't that the deal?
Yep, that's the deal.
That's the deal. So now they both come down to the South in 1865. Albion Tourget goes to North Carolina and, becomes this incredible activist and then a judge, yes. And Judge Ferguson goes to New Orleans and basically hangs out his shield and becomes a lawyer. So his thing was, we can't find anything that really talks about his views on race, but he was definitely a Puritan from Boston, and he totally flipped out when he got to New Orleans and saw this gambling and prostitution, and he was just like, no, we got to clean this up. So that became kind of his mission, and in so doing, he gets caught up with two politicians, Murphy Foster, who was then governor, and then Nichols, who, after he was governor, Murphy Foster puts him on the Louisiana as Chief Justice of the Louisiana Supreme Court. And these guys are, white supremacists, basically, throughout their lives. They want to get back to home rule. And so at the same time, they tap Judge Ferguson to fill a spot on the district court because the previous judge mysteriously disappeared shortly before that. And so these guys put Ferguson on the court, and most of his cases were, just burglaries and murder, whatever. But right away, he's hit with the first test case of Daniel Day-Dune and then Homer Plessy. And this is where the reason I brought up the parallels of the two is because, ironically, I think in some ways, even though we think about Judge Ferguson as being the villain or on the wrong side of history, when his decision upheld the separate car law as being a states' rights, the state had the right to regulate the railroads, and Homer Plessy violated their law, saying that they needed to go into a separate car. Judge Ferguson this is the moment he actually knows Homer Plessy's local lawyer, who was James Walker, and a former Confederate soldier, is defending Homer Plessy. And the strategy that Tourget and the Citizens Committee put together was to argue the case based on the 13th and 14th Amendment. And so they asked Judge Ferguson, you know, if they would, this is how they wanted to argue the case, and so Judge Ferguson says, fine, you know, we'll reconvene in a couple of weeks. And so they made their case, and Judge Ferguson says, you know, you made a very good case, but Homer Plessy did violate the separate car law. And so therefore, he upheld that decision. Here's the key. So in the meantime, Albion Tourget is this incredible hero, risking his life every day. The moment where Judge Ferguson says that Homer Plessy is guilty and decides not to set a trial date was his moment of heroism, which isn't saying a lot. I mean, compared to, you know, all these guys, Judge Ferguson was just not an activist in any way. And but he orchestrated with James Walker to postpone the case long enough for the Citizens Committee to appeal it to the state Supreme Court. And that was how the case began to move out of the district court and up towards the Supreme Court. And that apparently, according to Mr. Luxembourg and everyone else, because they found it in Albion Tourget's papers, that he went to the district attorney and on request of the Homer Plessy's lawyer to, you know, act in a way that this case get moved up. And so he did that. You know.
You'll find that interesting letter. I just found it on Thursday. It was, in fact, a letter that James Walker had sent to Albion Tourget based on Albion Tourget's suggestion that the Attorney General talk to Judge Ferguson and how they were working that sort of procedural thing. And it did delay, which then created something called, and you can look it up, a writ of prohibition. And Judge Carter and or Judge Cass will explain that in detail, because I can't, but it's a writ of prohibition, which was the actual procedure that found its way to the Louisiana Supreme Court. Mm-hmm. And they, in fact, then ruled in a way of which then opened the door. It's called then a writ of error. Writ of prohibition, writ of error, and it's the writ of error saying the Louisiana Supreme Court erred, and that was now appealed to the United States Supreme Court. So that essentially what happened, and I read also, and you'll see the letters, that it was well orchestrated, and Judge Ferguson, without changing the law, he just simply paused and just took a deep breath, and which permitted things to happen, which opened the gates to work its way to the United States Supreme Court. So he's yes, in many ways, a hero.
Well, a little hero.
Small H. Yep.
Small H. But, what was I going to say? forgot. Sorry.
Walker?
Walker. Yeah, I tend to forget things when I'm talking. If I give a little backstory, then I forget my formula. I can't remember. Go ahead.
Well, anyways, then Walker and Tourget spend 4 years, 4 years, orchestrating briefs, petitions, how to set up an argument before the United States Supreme Court. And we talk about race. We talk about race, and he used something really distinctive, race as property. That's a property you have. If you're a white person, it's a property value. And the black, it's a property value. And in this particular case, 14th Amendment, you can't lose your rights to property without due process.
Right.
14th Amendment. So he came up with this sort of novel idea saying for Homer Plessy, 1/8 black. What is he? They've treated him in this law because of blacks and whites. If you're a black, your reputation gets skewed. It becomes less valuable. If you're a white, because you're in a white car, more valuable. So there's value attached to race. And he actually had Walker spend a lot of time researching the Louisiana laws to see if there was a definition of race. Because how do you charge somebody? There's many lawyers here, and in the wild world of criminal law, there has to be a definition of what you're charged, and then all the elements of the crime.
Right.
Well, all of a sudden, they found in a great deal of research, Tourget, Walker, there was no definition anywhere of race. So that became a pivotal part of the argument that worked its way up towards the Supreme Court.
Well, and that happened too, I think, correct me if I'm wrong, but I think, their original strategy was the 13th Amendment, which by putting black people in another car, they became second-class citizens. Therefore, that was a badge of servitude. Therefore, that was the 13th Amendment stated that you could not be, that former enslaved were free people, and therefore they couldn't be. And then on the 14th Amendment, that they had full citizenship rights, and therefore you can't regulate them to another car. But these arguments didn't work in Judge Ferguson's court. They didn't work in the Louisiana Supreme Court. They did use them in the Supreme Court, but again, the sitting justices found ways to, as they are doing today, interpret the 14th Amendment narrowly enough to say that that the state had the right to segregate the races, and it did not, and it was constitutional, not unconstitutional. And so the question of race became a key point that they were trying to say. What you're doing is asking this conductor to be, a judge and jury of passengers, of citizens riding on a train. And who could do that? So when Homer Plessy got on the train, the story, which way do you tell it? That the conductor asked Homer Plessy if he was black, or whether Plessy announced it?
Well, according to the plan, the conductor approached him and he asked him, was he a colored man? And he replied, yes, I'm a colored man. Purchased my ticket, I'm going to Covington. And he said, well, you will have to move to the car of your race if you're a colored man. Now, automatically you had, instead of somebody on another seat getting upset about it and getting into a fight with Homer Plessy, you had the arresting officer come in, C.C. Kane, who steps in and immediately grabs Homer Plessy and said, you got to move. Mm-hmm. And he gets him out of the train before a commotion happens on the train because you had other passengers.
Yeah.
So that's how it was it was orchestrated in a way where he wouldn't have any conflict with anybody. You know, and when he purchased the ticket office, when he went to the desk, purchased the ticket, they were waiting for him. They knew it was him when he got there. So they just sold him the ticket, no dispute.
And you know, when it came before Judge Ferguson, I remember he said that nowhere in their argument did they say that the second car was unequal to the first class car. And therefore, he said that Homer Plessy was just doing as he pleased when he violated it.
Well, the law itself to say that to promote the comfort of passengers. Which passenger are you talking about? Then you're separated by white and black, but which passengers are having comfort and which ones are not?
Right.
But
Right.
that was the law. That's the way it was written.
And what I was going to say before was that, so when Judge Ferguson agreed to working with them to do the delay, he had to have realized that if they got past the state court, that they would actually challenge it on a writ of error to the Supreme Court, which would make him the defendant.
Right.
And so therefore, he was putting himself, the case would become Plessy versus Ferguson. So for someone who is almost an introvert and stayed out of politics, race politics, I think that was interesting that he had to think. I mean, I didn't think about this for a long time, but it finally occurs to me, wait a minute. He must have known this was going to happen, and this was going to be a big case.
Yeah, the case, the way it was styled, and I'm looking at Judge Carter over there, but was styled so there was ex parte Homer Plessy. That's how it was before Judge Ferguson. And then it was ruling, and then enter the whole writ of prohibition process, the Louisiana Supreme Court. Now it's a writ of error because it's directing Judge Ferguson not to proceed with the trial.
Right.
And so that's that aspect, hence Plessy versus Ferguson. So that's how it flipped, if you will. And you're right, that's kind of an interesting, I never thought about that, but that put him in the limelight.
Right, and the question we get asked all the time is, how did it come to be called Plessy versus Ferguson? And so that's why you have to understand the progression of the case to understand that he suddenly becomes, instead of the judge, he becomes the defendant.
So they argued essentially before the Supreme Court on two aspects. This is Constitution Day. The 13th Amendment, which abolished slavery, and the 14th Amendment, which we'll get into some detail. The 13th Amendment aspect of it, the case, the way, again, back to the values, if you're a black, you essentially they created a caste system, blacks, whites, and that in Tourget's world and Walker's world violated the 13th Amendment. And with regards to the 14th Amendment, the aspect of value, and there's several other details. It's a long 80-page brief, by the way. By the way, that brief is sitting in Westfield, New York. How many people from Chautauqua Lake School here? Anybody Chautauqua Lake School? A bunch of people? All right, right down the road, Westfield, are all of the papers of Albion Tourget, including his brief that we're working off of right now, the actual document itself, and the notes that he argued before the Supreme Court. But among the things he talked about, the 14th Amendment, which is the confiscation of property rights. My property right to the sustainability of life without due process. By being put into a black car, that value of race went down. And he wonderfully put in his brief that justice is pictured blind, and her daughter, the law, ought at least to be colorblind. The term colorblind, that will come up. Let me read that again. Justice is pictured blind, and her daughter, the law, ought at least to be colorblind. A critical piece of the puzzle. Now, for all of you who should, I'm going to stop.
Yeah.
Please sign up your email, because in the packet is a bunch of fascinating work done by Hurwitz and Fine, the Abota folks, talking about Plessy, and also by my firm talking about specifically the source of the term Constitution is colorblind. It goes back to 1870. I won't give you all the details because you have to read it, but it's there in the brief and in the files. We'll show that this afternoon. So that is an argument that is made by Albion Tourget. And he went on to say something really profound and sort of right to the point. Now, the judges, you talked about the Supreme Court judges at the time were all pretty wealthy guys. They're all white. And he then says in his argument, suppose a member of this court, he's looking at the court, 8, as it turned out, one guy recused himself. There was 8 members. Suppose a member of this court, nay, suppose every member of it should wait tomorrow with black skin and curly hair, two obvious controlling indications of race, if so ordered by a conductor to change his seat, what humiliation, what race would then fill the judicial mind? She's looking at him in the eyes and said, what happened if you woke up by the mere accident of birth and you, the conductor, using his discretion, which he had complete discretion, and mandated you move? Would you think differently? Talk about difficult argument, but he did it. He looked him right in the eyes and said that. You know, that's where Albion Tourget.
And I'm sure they had nothing to say.
Well, they said a lot in the opinion that it didn't affect them
Well,
whatsoever.
yes, right.
As the case worked its way through, do you get a sense of, back in New Orleans, there's the Citizens Committee. It starts its way through the judicial process, and that's where it should be. That's where they wanted it to be, 1892. Many years pass, like 4, till it gets to the Supreme Court. Do you get a sense in New Orleans, was the Citizens Committee, Louis Martinet, that's what I say, what they were talking about? Did they have in a sense of optimism, pessimism?
Well, the makeup of the Supreme Court, the U.S. Supreme Court, was changing around that time, in the period of time that passed. So even the gentleman Nichols, who was mentioned by Phoebe as being an associate in Louisiana, was appointed to the U.S. Supreme Court around that time.
No, not Nichols, Edward White.
Ed White,
yeah. But Nichols was the governor at that time. And all those things were changing. You know, you had massacres that happened like Colfax, Mechanics Institute massacres where, you know, hundreds of black people were murdered. And Nichols had a lot to do with it.
Yeah, Murphy Foster
as well. So these were associates of Judge Ferguson. So throughout that time, they were experiencing a lot of violence in New Orleans, leading up to the Plessy v. Ferguson case, that 4-year period.
Well, and the country was, in part, even though it hadn't been reached the Supreme Court, the segregation laws were increasing, and the violence was increasing, and they became, I know Louis Martinet became very disillusioned and concerned that they would not win the case. And, but, you know, they stayed with it and made it to the Supreme Court in 1896. I mean, 1895 was something about 1895.
Yeah, they set the case down for 1895, and then they actually argued it in
1896.
1896,
Yeah.
And so they literally, on April 13th, 1896, before 8 members, David Brewer was absent, Tourget argued, a guy named Phillips, who was the hired gun by the Citizens Committee from Washington, was there, and then also a hired gun on behalf of the Louisiana was there as well. I mean, Judge Ferguson had the whole state, of Louisiana. Of course, they had to protect the law. It was the law that was at issue here. And I just, probably for the sake of timing, the decision came down. It was 7-1 in favor of Judge Ferguson, and M Plessy lost. M Plessy lost. The sole dissenter was John Marshall Harlan. What was the opinion, briefly, was given by a guy named Justice Henry Billings Brown, that dealing with the 13th Amendment, separate cars had nothing to do with servitude. He just washed it away. Nothing to do with it, guys. And he went on to say, a statute which implies legal distinction between white and colored has no tendency to destroy legal equality of the two races or reestablish servitude. And he basically said Louisiana had the police power, convenience, and kind of used some very ambiguous terms that they had the power to do what they did when they passed the legislation and endorsed that particular custom. John Marshall Harlan was the dissenter. One guy dissented. And he went on to say a couple of things of note, many things of note. It's worth reading the dissent. In my opinion, the judgment will, in time, will prove to be as pernicious as the Dred Scott case of 1857. That's when it was decided that a black, by definition, was not a citizen.
Right. Are you all familiar with the Dred Scott case?
Go ahead, wait, give it a little background.
Well, that was the case where it was decided by the Supreme Court of the United States that a black man was considered to be 3/5 of a human being. And this was law.
How would you like to be considered 3/5 of a human being? Does that seem something you can relate to? Okay. So they didn't either. Go
No,
ahead.
but just on a note of victory, because we're talking about losses in U.S. Supreme Court, Dred Scott, Plessy v. Ferguson. In 1852, the state of Missouri betrayed Dred Scott and his family because there was a once free, always free law. And when Dred Scott went to another state in 1852, which started this whole process with him in the 1857 case.
Dred Scott was a slave.
And he was trying to get his freedom. He went to a state with a man who owned him previously, and he was considered free when he went to the state where it was a free state and not a slave state. Well, that freedom was short-lived. And in 1852, Missouri, the state of Missouri, turned its back on Dred Scott and his wife and sent them back to slavery. Now, I was a witness on March 26th this year, went to St. Louis, Missouri, to witness Dred Scott's charges in Missouri State Supreme Court renounced by the legislature, by the Senate and the House, unanimously, Republican, Democrat, you name it. Everybody unanimously approved of his charges being removed. And just like you saw the DA announcing Homer Plessy's charges being removed and him receiving a pardon, same thing happened for Dred Scott on the state level. Now the 13th, 14th Amendment, and 15th Amendment were supposed to have changed the ruling in the 1857 case where he was considered 3/5 of a human. And they considered that the 13th, 14th, and 15th Amendments had removed that in a sense, but they still have to have, and I think we still have to have a day in U.S. Supreme Court where that's considered null and void.
In fact, that's a good segue to the continuation of the dissent of John Marshall Harlan, who famously said that in the view of the Constitution, he was mad, he was really mad. In the view of the Constitution, in the eye of the law, there is in this country no superior, dominant, ruling class of citizens. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. Let me repeat that. In the eye of the law, there is this country no superior, dominant ruling class of citizens. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. The term colorblind, interestingly enough, was argued by Albion Tourget in his brief. Is there a connection?
Oh, yes.
Is there a connection?
Yes.
A guy from Mayville, New York, right up the road, wrote that in Mayville, wrote those words in Mayville. And it's now become iconic in constitutional law, and Justice Marshall Harlan has subsequently been revered as a great dissenter. I'll digress for just a second, because we know the end game here is in 1954, Brown versus Board of Education, which ruled that Plessy versus Ferguson is no longer the law. No longer the law.
It
And-
overruled it.
It overruled it, and Robert Jackson, our guy, was part of that court. And I will go into maybe some detail later if time permits, but what was interesting, and I didn't know this, the New York Times in blazing headlines in a big editorial said, Justice Harlan concurs. Justice Harlan concurs on Brown versus Board because of what he said many years earlier in Plessy versus Ferguson, which is just a fascinating how time gives the benefit of a dissenter's view, and it goes towards exactly what our earlier district attorney, Jason Williams, talked about. You know, if you have a feeling, feel it. Kristen McMahon talked about that earlier today for students, and that's a really credible object lesson. So Homer Plessy, unfortunately, loses in 1896. Do you have any sense at all what his reaction might have been? Do you have any history that, I realize that's not what you wanted to have happen, but nevertheless, within the family, has anybody ever got a sense, did it bother him? I mean, what was the reaction?
Well, it's kind of tough because our history is not accounted for as much as, the history of those folks that won the case in that time. And maybe even Judge Ferguson on his obituary, you had a little bit of attention there. But when Homer Plessy died, it was like just a blank thing almost in the paper.
Actually, it wasn't mentioned in Ferguson's obit.
Not at all.
Not at all.
Yeah. But back to the family, we never discussed it at the kitchen table when I was growing up. We never discussed the case. I have a biology professor at University of Virginia who probably could have been the voice of our history, but he never pursued it. And here I come along many years after he passed through the colleges and so forth. And I'm a bellman at the Marriott for some 40-some years. And in 1996, when I think your author, Elliott?
Yep, Mark Elliott.
Mark Elliott. In 1996, I get introduced to the case by Mr. Medley. And from there, I'm totally interested in finding out about my ancestor. And eventually, we meet through his book. And I'm chosen as the one to tell the story now.
Yeah.
So it's
But
kind of humbling. It's humbling because I get some calls from some of my family members at times, those that kept telling me in the beginning, what are you doing, man? That's just history, You keep talking about that same thing, Even my daughters kind of doubted, when we started talking about the case and trying to get the recognition for the Citizens Committee that they deserved. My family didn't go along with it too much. But now I think when the governor signed that pardon, I think it got their attention.
Now, but along the way, you did meet some civil rights activists, didn't you?
Oh, wow. And I can attest to the Marriott being the place where I met them. Muhammad Ali for the second time I met in the Marriott. And the biggest person I could say that I ever met, who actually gave me she probably put a sword on my shoulder and sent me on my way to do the work.
Give you
And it
marching
was
orders.
Rosa Parks. And
Not everybody meets Rosa Parks, so talk about that a little bit.
yeah, well, I'm at work in 1996, and 1997 rolls around, and they had the case. They had a big gathering in New Orleans with all the people from around the United States recognizing the case in 1996.
Because
It was the anniversary, the 100th anniversary of the case. And they did a mock trial for the U.S. Supreme Court case. You had all the people there, John Hope Franklin, Constance Baker Motley, all the people with the NAACP were there. And I made some of the events, but that very next year, I'm working and all my coworkers were referring to me as Plessy versus Ferguson. I wasn't Keith anymore. So one of the guys says, hey man, you know, Rosa Parks wants to meet you. And I said, come on man, why you doing this? You know, I mean, every day I'm hearing Plessy versus Ferguson. Can I just be Keith? So he said, no. Rosa Parks is in the GM suite, and I told her your name, and she wants to meet you. So I said, well, okay. So I run to the GM suite, tap on the door, and she happens to be traveling with Cicely Tyson. So that's who opens the door. I said, well, hi, Miss Tyson. She said, oh, you must be that Plessy boy. So I said, well, yeah. So I walked to the back of the room, and Rosa Parks is sitting in this big chair. And I automatically, because that's my idol. You know, she did what my ancestor did a long time ago, and I idolized the woman. She was considered the mother of the civil rights movement, the modern civil rights movement. So when I kneeled on one knee and said, thank you, my queen, for all your hard work, she said, get up, boy, your name is Plessy. You got work to do. I can tell you, I didn't get it then. I really didn't get it then. I was too shocked. I didn't ask for an autograph. I didn't say, can we take a picture? Nothing. I was blank. So, you know, she gave me a rose, and I tried to preserve the rose for like 2 years. It crumbled, and I have it in the paper, and it just went away. But she died during Hurricane Katrina, when we were displaced, and I was in Memphis at the time. I was working at the Marriott there. So there was a guy that came by, and he had the obituary, the original. And I said, man, could you make me a copy of that? So he makes the copy, I get the copy, and I'm back, eventually back 2006. That happened in 2005. 2006, I'm back in New Orleans. And I'm in the lobby, and this lady comes in, and I asked her, where are you from? She said, well, I'm from Montgomery, Alabama. So her name was Miss English. She was working in the church at the time in Montgomery. And I said, well, I have a photocopy of Rosa Parks' obituary. And she said, really? I said, yeah, yes, ma'am. I'll make a copy for you. She said, son, Rosa Parks is my best friend. I have an original for you. So I have the original of her obituary. Yeah.
I didn't know that.
It's a good thing you showed up.
Right. Just went back to work normal. And there you go.
That's got to go
Back
in
in
the
the
archives, I think, doesn't it?
Well, it's a perfect way to kind of get our way towards winding and get these guys back to class. But Rosa Parks exhorts you, get on with the business. What is the business now of Plessy and Ferguson? We know you met through autograph signing, book session with Keith Medley, and next thing you know, and so what's the mission here? Give us a charge.
Well, our mission is, on the one hand, is to honor the work of the Citizens Committee and their courage and fortitude to take this case to the Supreme Court. And we do that by teaching the history of the case and why it's still important today. And you can, if you're following the news, you can understand with the attempt at reinstituting voter suppression laws and over-incarceration and, even using overturning Roe, using Plessy to overturn Roe, brings us into, the case stays in the contemporary discussion about equality. So we do this in a few ways. We do what we're doing right now, talking to students all around the country, and we put up historic markers. One of the first things that we did, between the time we met and the time we founded the foundation was about 5 years, and we wanted to create in New Orleans a trail of monuments and honoring the work of African Americans in the city, the achievement and the resistance, and so that it would be a visible understanding of the existence and the, who really created New Orleans to be what it is, and who obviously the economy was based on slave labor. But there were nothing to, for people coming to the city, how would they know? So we put up historic markers, and the first one was the Plessy v. Ferguson case, and that was unveiled on the day that we announced that we would become a foundation. And since then, we've put up another 4 markers that honor Keith's
take it from there.
elementary school. Yeah.
I would say one of the most successful markers that we put up is evidence in a school building called now the TEP Center, representative of Tate, Etienne, and Prevost. Now, everybody knows the Ruby Bridges story. Everybody knows about Ruby Bridges?
What do you know about Ruby Bridges?
But desegregation of public schools in the South, and a 6-year-old girl going into a William France elementary school for the first time in 1960. Well, her story is a Disney movie. There's a book, but there were 4 girls who was involved in that case. It's called Earl Benjamin Bush versus Orleans Parish School Board. And to show you how stubborn the Louisiana legislature was, that case was filed before Brown in 1952. And Earl Benjamin Bush was too old to go to elementary school by the time the case was recognized. Brown was decided in 1954. In 1960, 6 years had gone by in Earl Benjamin Bush's life, so he wasn't an elementary school student anymore. And they had to select 4 girls to integrate the public schools at the time. And just to show you how rough it was there, it would be more safe for them to select 4 girls than 4 boys, because there was this myth that the boys would attack your white daughters and you would have a problem. So they had 4 little girls to integrate the public schools. 2 schools, William France, Ruby Bridges by herself, and 3 girls, Leona Tate, Gail Etienne, and Tessie Prevost, integrated McDonough 19. Now, by that one story coming out about Ruby Bridges, you would think that that was the only person, the only girl that integrated the public schools. But neglecting those other 3 girls, it kind of nullifies the case itself. And what we wanted to do, when we came out of the gate, Keith Medley was a big influence on this, an author of the book We Is Freemen. We wanted to recognize those 3 girls and the school they went to. So by the time we, in 2010, found the school almost ready to be hit by a wrecking ball, we had to go and put that marker up before the school board tore the school down. And we advocated, we got everything going. We worked with the Leona Tate Foundation for Change, which is one of the girls who now runs the TEP Center. But in 2010, we stopped them from tearing the school down. And over the period that went by, over about 11 years, 10 years or so, Leona Tate never gave up the fight. And her foundation, Leona Tate Foundation for Change, now houses the school that's been renovated with over $16 million to maybe $20 million to get the school refurbished. And they've taken the first floor of the school and turned it into an interpretive center and they'll deal with anti-racism. They have a group called the
People's Institute.
People's Institute for Survival and Beyond, who'll be housed in that area on the first floor. And on the top 2 floors of that school building is 25 elderly, affordable living spaces. So you're taking care of the elderly, you're taking care of the young, out of a center where racism refused them to be students, is now a shrine to peace. So,
He's just saying that, you know,
and
the-
our
the marker
started
lead-
that process.
Right, exactly.
And talking about marker, I am looking at and Plessy and Ferguson Foundation, together, the importance of acknowledging the complicated past when building a stronger future. An inspiring response to the separate but equal Supreme Court decision of Plessy versus Ferguson. We have been blessed today, ladies and gentlemen, to have in our presence Plessy and Ferguson. So to Keith Plessy and to Phoebe Ferguson, many thanks.